In this module, we're going to look at the basic relationship between principals and agents, and then we're going to expand that understanding to look at partnerships and corporations, which are really principal-agent relationships in just a large-scale form. And we'll look at the various responsibilities and duties of the different parts of the modern corporation. So let's start, though, with agency and the way it works when we're just talking about one principal and one agent, so that we understand that. So an agency is a relationship where one person, known as the principal, intends for another person, known as the agent, to act on her behalf. So pretty straightforward. If I ask you to do something on my behalf, you are my agent with regard to that particular task. And an agency relationship can be created by an express agreement, but it could be an implied agreement, it could be an oral agreement, it could be a written agreement. An agency relationship can also be created by estoppel, which means the principal indicates to a third party that someone's going to act as her agent. And then that person is deemed to be the agent for the purposes of that particular transaction. There could also be agency by ratification, which means that I may not have intended, I may not have authorized someone to act on my behalf, but after the fact, the person has done something and I say, okay, that's all right, I'll be responsible for what they did. And so that's me ratifying the principal-agent relationship after the fact. And also, we could have a principal-agent relationship created by necessity, which means that a principal will be held essentially as a legal matter responsible for the agent's acts during some emergency situation. So, for example, if a child receives medical treatment while away from home, the parent can be held liable for the child's treatment because the relationship will be viewed as an agency relationship created by necessity. Notice, you don't need a written agreement to create an agency relationship. Some states, however, may require a written agreement if the relationship involves one of the sorts of contracts that are covered by the statute of frauds, which we looked at in our earlier module on contracts. Now, let's assume that a principal-agent relationship has been created. Basically, an agent owes three important duties to the principal and may be held liable for breaching any of the three duties. The three duties are the duty of loyalty, which means the agent cannot act in ways that benefits herself to the detriment of the principal. It also means that the agent may not take for herself an opportunity that belongs to the principal. So, for example, the agent can't secretly make profits from a transaction that she's engaged in on behalf of the principal, something like that. So that's the duty of loyalty. There's also a duty of obedience, which means that the agent has to obey all reasonable instructions that the principal makes. And there's a duty of care, which means that the agent must carry out her duties in good faith and with reasonable care. It may not be to the letter of the instructions in certain cases, but as long as it's done within the duty of care, then it's okay. So duty of loyalty, duty of obedience, and duty of care. And if all of that happens, if the agent is acting within the scope of the principal-agent relationship, then the principal is going to be held liable for the actions of the agent. Now, that depends on whether the agent is acting within the authority of the principal. And there are a couple of different ways in which that authority can be wielded. There might be actual authority. Actual authority is authority that the agent reasonably believes she has based on her interactions with the principal. So you can have actual authority, as I said, by express agreement. It could be implied agreement, but it's actual authority because the agent thinks that the principal has asked the agent to do something. Now, you might also have implied authority arising from an express agreement because it may be that there's an express agreement to do one thing, but that implies doing a bunch of other things that are necessary to do the thing that was agreed to. If actual authority exists, either implied or express, then an agent's act binds the principal, unless, of course, the authority has been terminated prior to the act. And actual authority can be terminated if the agent relationship has expired, or sometimes after a reasonable time period has elapsed, even if it hasn't technically expired. Or maybe there's a change of circumstances that would cause the agent to believe that the relationship has been terminated, or the agent has breached her duty, in which case that almost certainly will terminate the relationship, or there's notification from one party or the other that they want to terminate the relationship, or one of the party dies or loses their capacity. Now, another important concept in thinking about agency is what's known as apparent authority. This is when a principal leads a third party to reasonably believe that the agent has the authority to act on her behalf. And so if there's apparent authority, then as long as the agent acts in a reasonable way, they will be deemed to be the agent of the principal, even if the principal hasn't expressly created an agency relationship. Now, if the principal sends a notice to the third party and says, this person does not act for me, then, of course, the principal-agent relationship will not arise. But as long as that doesn't happen, if, for whatever reason, the principal has led a third party to believe that this person acts on the principal's behalf, then the principal will be liable for the agent's acts, even if there was no express or implied agreement. Now, if the agent does not have authority to act, then of course the agent will be liable for any transactions to which she enters. If the agent does have the authority to act, then the agent will generally not have any liability for her actions. That makes sense. But liability will sometimes be imposed even if there is a principal-agent relationship. And we should look at a few circumstances where that might be true. So it's clear that if the agent does not have authority to act, then the agent will be liable for any transactions in which she enters. But if the agent does have the authority to act, then the agent will not have liability. So it matters a lot to the agent whether they really have authority or whether they don't. But in addition, it also matters to the agent whether the third party with whom they are dealing knows that the agent is only an agent and is acting for some other principal. If the agent does not tell that third party that the agent is acting on behalf of a principal, in other words, if the principal is undisclosed, the identity and even the existence of the principal is not known to the third party, then the agent is potentially on the hook for any negligence that might result. The agent can't take advantage of the principal-agent relationship if the agent has not disclosed the principal-agent relationship to that third party. Conversely, if the agent does disclose it and says to the third party, you know, I'm acting on behalf of someone else, then the agent is protected. And anything that might happen as a result is going to be on the principal, not on the agent. And sometimes it might be in between, which is that the agent says, I'm acting on behalf of a third party, but I'm not going to tell you who the third party is. In that circumstance, potentially both the principal and the agent might be on the hook if negligence is committed. and that's called a partial disclosure. So it really matters for the liability of an agent whether the agent tells a third party that he or she is acting as an agent on behalf of a principal, and whether the disclosure of the principal's identity is revealed to that third party.